These guys got caught with their hand in the cookie jar. They embarrassed the governor, they embarrassed the attorney general, the legislature, and they should have embarrassed themselves. You know, for one of their lawyers to stand up and say that we are the attorney general and we are the legislature when it comes to game and fish matters is asinine. That is obnoxious. They are not anything close to that level, and I've had legislators and others talk to me about that because they're incensed. That was not a very smart move. You know, those guys, if you read what they did, they noted that they tabled the motion. They didn't do away with it and say, let's go to a judge and get him to sign off and we're going to do away with this forever. What they did is say, we tabled it. Now, anytime you table something, you've got an intent there. At some point, you may bring it back or will bring it back. And that's exactly what those guys are planning to do. Jim Goodhart even went further by saying that he still had some things that needed to clear up and change under the current FOI to accommodate the Game and Fish Commission. They don't get it. The legislature, the governor, nor the attorney general want them to change anything. The FOI has been very effective, very successful, and the Game and Fish is not going to get a variance. And I'd venture to say, after jumping out there and saying how they were the legislature and the attorney general when it came to their business, they won't be getting much help from either one of those if they try to present something. But let me tell you, with that in mind, we had our case based primarily on the Administrative Procedures Act. And as I noted a minute ago, we had only 2 applications during my 7 years on the commission, and both of them were for very minor things. Yet they came up here and passed an in-depth new program, and they called it bylaws and rules and regulations, but they've used the word bylaws, showing that they took what we used to consider our bylaws, which is what we operated under the 7 years I was there, and every other commission has going many, many years back, and turned that into what they wanted, which was a place to divert power from 7 to a group of 3. That became the little group of king commissioners, or whatever it was they were called in the recent articles. They had in mind they were just going to be the power of the organization from beginning to end, and then when they tried the Freedom of Information Act change, it was just to carry that one step further. Now, with that in mind, let me tell you what we filed today. We filed a few moments ago a proposal to go ahead and bring this matter to a head. We think that since they say that they want to follow the Freedom of Information Act, and since they're not sure what they want to do on our original filing, we have filed for a declaratory judgment with the judge, with the court, and we're asking the judge to, because of the way they left the FOI issue, which they did not put to bed, if you'll read their comments, we ask the judge to please let us include it as part of our other, because these are really sister acts. If you look at it, one is intended to make sure that you notify the press, that you have to notify the press when 2 or more members of a commission are together, that you've got 3 days to take care of FOI requests. It does the one thing. That's your freedom of information. But then when you take the other one that we had challenged under, it is very critical because it has to do with publication for knowledge. One of the major issues is that you are supposed to go to the Secretary of State, and this is required by agency laws, and we cite them in what I gave you, to give at least 30 days for individuals out in the state to state what they feel about what you filed, or to rise up and fight it as they would have had they announced this FOI thing. So I think that's a move that will smoke them out. If they truly meant that they're going to observe FOI from now on, going to leave it alone, they should come to our side and go to the judge and say, we're willing to accept that right now and want it to be part of the order. If they fight us, it'll show you what their true intent is. Now, on the Administrative Procedures Act, I don't think they've got a leg to stand on. If they're going to take state money, if they're going to take tax money, which they do, they're going to have to comply with both laws of the state of Arkansas, in my opinion. Now, the judge will say, and the judge will take the law and apply it. But I've never heard anybody say anything to the contrary till this group got together and decided they were going to take over the commission and wanted to reset the rules so they could run the commission with a very strong hand of 3 individuals at the helm and the other 4 commissioners on for the ride.